So good afternoon, everyone. Thank you for attending this webinar on best practices to manage non-performing payments. So in this webinar, I'm going to cover the following topics: current updates about Indonesia, basic explanation on payment defaults, what action should you take at the initial stage and enforcement stage, litigation in Indonesia, bankruptcy and Pkpu proceedings, and also tips to prevent on non-performing payments. Like other countries, Indonesian government is working hard on handling the COVID-19 pandemic. Currently, there are over 350,000 cases, and mostly are in Jakarta. This obviously has affected Indonesia's economy. Therefore, in order to boost the economy and increase the state income to maintain the financial stability, the Indonesian government has issued some regulations. For example, regulations in relation to tax, by imposing VAT on digital services. Therefore, it will require foreign entities to collect VAT from Indonesians who are enjoying their services in Indonesia, such as Netflix, Google, Amazon, and Spotify. With regard to financial institution, then the government actually give more flexibilities on calculating non-performing loans. This is to encourage local financial institutions to have debt restructuring with the borrowers or provide further funding that the borrowers which were affected by the COVID-19 could be supported by the local financial institutions. Also, in this case, the government is really only focusing on smaller size borrowers with the borrowing that's not more than 10 billion rupiah, that's around 680,000 US dollar. And lastly is about law on job creation or omnibus law, which was passed by the House of Representatives recently, but it has not been enacted yet by the government. So the reason why it is called omnibus law is because the law contains amendments of many laws. The government is hoping that by passing the omnibus law, doing business in Indonesia will be easier and therefore create more jobs in Indonesia. However, by passing the law, it has created a lot of protests in the public. One of the main reasons is workers feel that their rights have been reduced under the omnibus law. And with regard to the bankruptcy and suspension of payment cases, actually there have been an increase this year. The Indonesian government doesn't issue any moratorium measures of repayment of loan or contract defaults due to COVID-19. Basically, there are two types of payment defaults with regard to commercial contracts and loan agreements. With regard to commercial contracts, for example, supply agreement, sale and purchase agreement in respect of a product, service fee or consulting agreement, and assuming that the contract is clear, it will be considered a default when there is a payment that is due and payable, and it remains outstanding after the payment schedule. And it can be a payment of a purchase price and service fee or interest under the contract. In respect of the payment defaults under a loan agreement, that will be in respect of principal amount, interest, or any other amounts that's payable by the borrower to the creditor. So what should you do if there is a payment default? Firstly, you need to check your agreement first. What does it say in the agreement regarding your rights against your counterparty if there is a default of payment? For example, can you stop the next shipment? Can you charge interest over the outstanding amount? Or can you declare all outstanding amounts that's not due and payable to become due and payable so that you can claim the entire amount from the counterparty? And also, what's the governing law of the agreement? Is that Singapore law or Indonesian law? Or where can you sue the counterparty if you want to submit a claim against it? Secondly, also with regard to the communication with the counterparty, remember that you've got to reserve your rights under the relevant agreements, because without reserving your rights, you might have waive any of your rights under the contracts, and this may jeopardize your position in the future. And finally, which is not a legal point, but from my experience, it is also important that you maintain a good relationship with your counterparty and work together to find a solution or a settlement in relation to the outstanding payment. For example, you can reschedule the payment or reducing the outstanding amount, because if the relationship is ruined, it will be challenging to have a good outcome. After the initial steps which I have mentioned earlier, actually there is no magic trick to have the debts being repaid. It all depends on various factors: reasons of the defaults, amounts of default, and also financial conditions of the counterparty, as well as whether the counterparty is being cooperative. But regardless the governing law of the contract, if the counterparty is an Indonesian company or individual, under Indonesian law, you have to send a demand letter to the counterparty, which is referred to as somasi in Indonesian language, to state that the counterparty is already in default and you demand a payment of the outstanding amount within a certain time. And the magic number of this is by sending somasi 3 times. For example, every week or every 2 weeks. That is the practice. The reason is to show to the judge, if eventually you want to sue the counterparty in Indonesia, that you have tried to give ample time to the counterparty, but it remains in default. The somasi can be sent either by yourself or your Indonesian lawyer. But usually, if it is sent by a litigator, then the somasi will give you more weight, and you will actually make the counterparty to come to the negotiation table and try to resolve the outstanding payment with you. And the somasi shall be in Indonesian language, and also it can be in bilingual, namely in English and Indonesian language. If the counterparty pays the outstanding amount upon receiving the somasi, then that's the best outcome. But supposing that the counterparty is willing to pay, but it has some financial problem or liquidity problems, then the parties can discuss about how to restructure the debts, such as rescheduling the payment schedule, or some pay cut, for example, to reduce the outstanding amount or to reduce the interest payment. Restructuring regimes in Indonesia is actually simpler than Singapore. Debt restructuring may be carried out through private debt restructuring or court-sanctioned debt restructuring, which is usually referred to as Pkpu. The key differences are set out in the table. For the private debt restructuring, it doesn't involve any courts. The party just negotiate the debt restructuring privately. You may have a discussion on the debt restructuring with the counterparty before or after sending the somasi. But for the debt restructuring through Pkpu, it involves the Indonesian commercial courts, which I will discuss later on. The private debt restructuring, the restructuring agreement only binds the relevant creditors with whom the counterparty or debtor has a restructuring agreement. But for a Pkpu debt restructuring, it binds all creditors subject to certain exceptions. Last point is with regard to the timeline. There is no timeline to conclude a restructuring agreement for private debt restructuring. It's up to the parties how long do you want to negotiate the restructuring agreement. But in respect of Pkpu debt restructuring, there is a strict timeline for you to follow. And if the settlement agreement cannot be achieved within that timeline, then the debtor will be declared bankrupt. Let's say there is no fruitful outcome from the private negotiation with the counterparty. You might consider whether to go through a legal proceeding to claim the payments. Depending what it says in the contract, you may litigate at a court either in Singapore or in Indonesia. If it is in Indonesia, you may litigate at a district court for civil claims or commercial court for bankruptcy and Pkpu applications. The contract may also have a dispute resolution clause to have any dispute to be resolved by way of an arbitration, either in Singapore or in Indonesia, or it could be in other countries. In terms of litigation, I'd like to highlight to you that foreign court judgments are not enforceable in Indonesia. Therefore, if you litigate in Indonesia against a counterparty that's from Indonesia in a Singapore court, you cannot bring the Singapore court decision or the judgment to Indonesia to enforce it, unless it is in the form of a foreign arbitration award, then it can be enforced in Indonesia. If you decide to file a claim at an Indonesian district court, you need to consider whether it is actually worth it, given the cost and the time involved. And it takes time to have a final and binding judgment because the court decision can be appealed up to the Supreme Court. If there is no dispute on the debts and it can be easily proven to the court, you may consider actually filing to the commercial court for bankruptcy or Pkpu could be an option because the process is faster, but it is costly too. Other factors need to be taken into account as well if you want to file a bankruptcy or Pkpu application is whether the counterparty has enough assets to be liquidated and share with all creditors in the event of bankruptcy. And in the event of Pkpu, what is your position? Are you a secured creditor or unsecured creditor? An unsecured creditor meaning that you don't have any security granted by the debtor or a third party. You don't have mortgage or pledge or any charges. And also it depends on the size of your debts. Because if the size of the debts is small, you may not be able to control the votes during the Pkpu application proceeding. In relation to bankruptcy and suspension of payment, they are regulated under Law number 37 of 2004. For filing a bankruptcy application, it is very simple. So there are certain general conditions which must be fulfilled. Firstly, the applicant shall be either the debtor itself or a creditor of such debtor. The creditor can be a secured creditor or an unsecured creditor. And their debts. And the applicant shall prove that the debts is a simple debt, meaning that it's not being disputed, and at least one debt must be due and payable. There are debts that can be used to file bankruptcy applications. There are all kinds of category of debts. For example, from commercial agreements or loan agreements. For example, outstanding sales price, outstanding service fees. You may also file an application to bankrupt the counterparty. An example of debts that cannot be easily proven is, for example, losses or damages, which you don't have a court decision or arbitration awards in respect of the amount of the damages. There is no actually minimum requirement on the debts. So technically, even for $1 debt, you can file a bankruptcy application. And for the minimum number of creditors, it has to be at least 2 creditors. And in practice, the second creditor needs to appear before the commercial court to confirm that it is a creditor of the debtor. And the application is made to the commercial court, which has the jurisdiction over the debtor. So what will happen if the debtor is declared bankrupt? When the debtor is declared bankrupt, a receiver or creditor will be appointed by the commercial court to manage the debtor and its assets. The debtor may appeal to the Supreme Court in respect of the commercial court decision and file a judicial review in respect of the Supreme Court decision. And the creditor have to submit the claims to the receiver for verification. All the unencumbered assets of the debtor and then will be liquidated by the receiver for paying the debts to all creditors. In relation to the suspension of payments, or usually referred to as Pkpu in Indonesian, the requirements are basically the same with the bankruptcy application. And also, the timeline is actually shorter. The commercial court shall give a decision to approve or reject the Pkpu application within 20 days from the date of the application. And if the application is made by a debtor, then it can give the decision within 3 days. Please note that there is no legal remedy or appeal in respect of the Pkpu decision. So if the commercial court rejects or approves the application, such decision cannot be appealed by the parties. So what are the effects of a Pkpu? What if a debtor has been declared under Pkpu? If the Pkpu application is accepted, then the debtor may continue to manage its company, but it may not take any action in respect of its assets without an approval from the administrator, or we call it pengurus. The creditors may not take any actions to demand payments of the debts or to enforce the security. But once the settlement plan or the agreement has been approved by the creditors and the court, then the administrator doesn't have any authorities to manage the company anymore. There are two periods of Pkpu, namely temporary and permanent Pkpu. Temporary Pkpu is granted maximum 45 days from the date of the Pkpu decision. And if during the 45 days period, no settlement plan is achieved, a permanent Pkpu can be granted based on the voting of the two categories of creditors, namely the secured creditor and the unsecured creditors. Permanent Pkpu, including any of its extensions, cannot be more than 270 days from the date of the Pkpu decision. So if there is no compensation or settlement plan is achieved during this period, the company will be declared bankrupt. So how the court approved the permanent Pkpu of the extensions and also about the settlement plan? The court will require votings from the creditors from each categories, secured creditors and the unsecured creditors. And then for each category, it must approve by more than half of those creditors by the numbers of the creditors. And secondly, also by the amounts of the debt, which must be at least 2/3 of the total amount of the debts of those creditors attending the creditors meeting. So those must be cumulative votes between the secured creditors and the unsecured creditors. Lastly, I'd like to share with you some tips on preventive measures to reduce the risk of non-payment. Firstly, the importance of due diligence against the counterparties, which you should check about the financial condition, whether any cases involve the counterparty at the Indonesian courts, and also any existing obligations to other parties. And you should have a good contract and also keep all your documents, correspondence in an organized manner, because it is very important to have those contract and complete filing, because in the event of default, it will be challenging to protect your interest if you don't have a well-drafted contract or you cannot find complete correspondence as the evidence to support your case. And as mentioned earlier, it is also important to maintain a good relationship with the counterparties, because this will make them be cooperative and also acting in good faith to resolve the non-performing payments. Also, finally, the last point is with regard to checking at the Jakarta Online Bankruptcy and Pkpu database. It will be good if you or your Indonesian lawyer can help you check regularly if the counterparty is being registered as a party in a bankruptcy or Pkpu case. The search is free of charge, but the website is in Indonesian language. The earlier you know, the better, so that you can prepare your next steps and also to protect your position. So that's my presentation about the best practices to manage non-performance payment for Indonesia. I hope it is helpful to you, and thank you for watching. I shall now pass it over to Tiffany.
Thank you, Rina. Thank you so much. Okay, I've received some of the participants asking, hey, what about Singapore legal issues? Now, I'm pleased to have with us our second speaker, Mr. Justin Quek, Supervising Associate at JWS Asia Law Corporation. Now, he'll be covering more on the Singapore sector area here. So basically, he'll be presenting an overview of the regulatory measures introduced to address default arising from the COVID-19 pandemic and the options available for a non-defaulting party in Singapore. So can I have with us Justin?
Thanks everyone. Thanks Tiffany. Thanks Rina. So I think I've had a quick glance at the questions that have come up, and I see that people have been asking what can they do if you have a defaulting debtor in Singapore. So I hope to answer some of your questions in the course of this presentation. And I think what I've tried to do is I've tried to keep this as practical as I can. So I'm going to go through 5 broad bullet points here. First stage, I think before we get to the point of identifying what you can do with respect to defaulting counterparty, what you want to do is to identify the risk. So I plan to go through other telltale signs of a potential troublesome counterparty. And then once you have that potential default, potentially distressed counterparty, you then undertake a risk assessment, because the amount of risk and the cost involved, and the potential recoveries affects your options and the considerations as to what you want to do, which is my third bullet point. After that, I will briefly touch on the restructuring and solvency regulations in Singapore before closing off on the COVID related measures. So I'll jump straight into the first bullet point. So I think as in the course of this year, many of you who have read the news, you have seen several very high profile counterparties, high profile companies that have gone into default. Obviously, the biggest one has been Hin Leong and Ocean Tankers, Zenrock, Agritrade. These are the most high profile ones, and the question then, and I can say this because I've been involved in all four of them actually, is how do you know when a company, how do you know when a debtor is going under? And that there is no magic solution. It's about sort of trying to piece together the various strands of evidence, things that may be in your face, but you don't realize it because you have a long-standing relationship with the counterparty, and then you don't really realize until at the end they realize that actually all these warning signs are in your face. So this is what I figured out. So one is when you've got repeated extension requests for repayment. So you may have a counterparty that you have a long-standing relationship with for several years, and then abruptly you start to see the odd extension requests for repayment. Perhaps one or two is explicable because you may have that counterparty may have a very discrete cash flow issue, but if you see repeated requests, then you have to ask yourself what is happening, right? And the next, quite a telltale one is actually avoidance of contact with you and other creditors. So each one of you have your own industry contacts or industry peers, and if you start to notice, from your coffee shop talk, whatever, that hey, you've got the same counterparty trying to evade contact with his other suppliers or his other payment counterparties, and you have to ask yourself, why is that so? Next will be an abrupt change in payment methods. So sometimes you may have had cash on delivery or so on and so forth, and then now you're being asked, hey, can you take a check payment? Can you take a deferred payment from a third party receivable, so on and so forth? And then obviously the actual default itself, and then the possibility that you may have to call on personal guarantees or guarantees given by related companies. And then you've also got a couple of other related warning signals. I think the most visible ones, I think from a commercial perspective, will be the scaling down of operations. So I think if you look back at the recent examples, before Bakerzin actually went into liquidation, there was news that they were starting to close down outlets. So they were scaling down operations, and that again is another telltale sign that perhaps the company isn't doing so well. So it's looking to cut costs, reducing unprofitable lines of business. And then loss of staff. This of course happens because one telltale sign is because we as outsiders, and I say we as an external counterparties, you don't have visibility over the actual operations and cash flow of the company. The people who have that visibility are the internal guys. So this is your staff and your directors. So more often than not, I think that but some of you have will notice better. Your staff are very sensitive to their salary payments, and if there is if it appears that one or two salary payments are missed, they may leave. And also if they have a sign that the company isn't doing well, naturally they will go on to look for better better options. So these are again some things that you need to be mindful of. Audited financial statements is another. I've left it there. It is something that could cut both ways. Sometimes there are genuine reasons as to why financial statements can't be finalized in time, so on and so forth. But I think you have to look at it in the entirety. And when the financial statements are filed, do you have qualified opinions, and what are the qualifications? What are the disclaimers? And examine them. And then you've got registration of charges, abrupt registrations of charges. So I'm not entirely sure how many of you are in this audience actually are in the practice of taking security in the form of charges. But as you may know, for instance, charges over bank accounts, so on and so forth, must be registered with ACRA. So if your counterparty is traditionally clean, so on and so forth, and then in just prior to its insolvency, you see a bunch of charges being registered. The question then is, why are other creditors doing it? Do they know something that you don't know? And this information that's fairly easy to obtain. You just need to do an ACRA search. It can be done on the ACRA BizFile website. Can't remember how much it costs, maybe $5 or $10, but you'll get a sense. I mean, it gives you a fairly clear picture of what is happening in respect of security which the company is subject to. Of course, litigation and winding up applications being filed in court. I think this is where Rina ended off. I think in any reasonably sized business, you will end up being involved in litigation at some point in time. And the question then is there an increase in litigation? What stage of the litigation are the matters at? And also, are there winding up applications being filed against the company? Because I think if a winding up application is being filed against the company, that's probably the most telltale sign that the company is insolvent, unable to pay its debts. And of course, fraud-related news and rumors. This is again something that is not just in the mass media, it's not just in the Straits Times, Lianhe that you see. It can be a coffee shop talk, because people talk to each other, people have news. I'm sure in the industry you guys will speak with each other, and it's a question of whether or not you are hearing related news from different sources that there are potential malpractices, CAD investigations, so on and so forth. So I do want to stress that in these two slides, there are, I think, many different bullet points here. And the point is this: there is no one single factor that points to the insolvency of a company other than perhaps the actual winding up order being made. But what I'm saying is that take a step back, especially for those of you who have a slightly larger scale businesses. Sometimes your front office guy, your RMs, your relationship managers, the guys who are in charge of the customer relationship, they may not necessarily see this, or rather the facts may be in their face, but they may not piece everything together. So one thing that we do tend to do from time to time is we ask if our related if for instance the a person from a different department, for instance the risk department, credit department, can go in and say, hey, look at all this. Is there something I want to be concerned about? It's about taking a step back, looking at all the factors to understand whether or not there is a potential, you're looking at a potential defaulting counterparty. So those were the early warning signals. And once you have identified that there are enough early warning signals of a potentially distressed counterparty, the next question then is, what do you do? So we come to the risk assessment stage. So again, I recap. You have to look at the warning signals. Are they isolated? Are they cumulative? Do they, when all put together, is there a course of conduct which gives rise to some degree of concern? And in that event, you then have to assess what is the risk to your business. Hopefully, it is not one. I think some of you may have heard this phrase, where there is some degree of cluster risk, such that you're so reliant on that one single counterparty that counterparty cannot fail. Because if that counterparty fails, there will be a significant impact on your business. Hopefully, none of this falls within the category, but there is always that consideration. Okay, and what you have to do is that you have to, I think, holistically assess. I think the starting question always is this. Apart from cluster risk, which I've mentioned, the other risk is this: is there a risk of fraud? Is there continued trust in the existing management? And the reason why I say this is this, because if there is a risk of fraud, there are very good chances that the business is going to be very difficult to be saved, because especially the fraud is systemic and permeates throughout the entire business operations of the company. And oftentimes the counterparty may come along and say, oh, give me a bit more time, can I get more credit lines, so on and so forth. This is just a temporary thing. But if it is fraud, then there's a pretty good chance that they are taking that money and applying it for their own dishonest purposes, in which case your prospects of recovery are going to be very limited. Again, there is no whether or not there is potential fraud is a whole entirely different story. I think many of the high-profile incidents this year, if you ask many of the bankers who were involved in those incidents, they would probably say, no, we could not have ascertained that there was fraud on such a large scale involved, because there is trust in existing management. So what you need to do, again, it comes back to what I said earlier. Maybe what you want to do is you want to take a step back, get your other guys in risk, credit, compliance, even another department, say, hey, let's take a step back. Is there something that we want to be concerned about? Is there a risk of fraud? Do we trust the existing management? Okay, and of course you then try to cut down on your risk, on your exposure levels. Can you reduce your existing exposures? This may be in the form of, for instance, reducing your connectivity, your supplies to this existing customer or counterparty, reducing the number of shipments, your consignments, so on and so forth, such that you manage your risk a little bit better. And then you also want to look at whether or not you have other recourse. This may in the form of guarantees, securities, or quasi-securities. Quasi-securities is, for instance, deposits that they've left with you. Do you have a right to set them off, so on and so forth? And then you have to ask yourself whether or not you can obtain fresh guarantee security or quasi-security from credit-worthy third parties. Usually this will come in the form of directors of the company, especially if these are family-owned companies. Or if not, this can be from related entities. Worst come worst, or let's say worst come worst, but one possibility as well is the possibility of taking an assignment of receivables from that party's debts. And it's key that you try to obtain it from a third party, because if you obtain it from the existing counterparty, if the existing counterparty is going under, then there is a risk that any security or guarantees that are taken will be subject to a clawback risk if the counterparty goes into liquidation. Okay, then of course, you should also be pulling out all the relevant documentation. This relevant when you consider enforcement, i.e. all the existing contracts, invoices that you have, if they're related security documents, pull them out, put them together, and look at them holistically. If you have your in-house legal, get your in-house legal to start to look at that from a legal point of view. And then before you take any step, and this is actually very important, is before you jump the gun, pull the trigger and decide, okay, I'm going to sue, so on and so forth, I'm going to start issuing statutory demand, so on and so forth, ask yourself, think about it from an enforcement point of view. I think one thing that Rina has already mentioned is this: Indonesian courts will not enforce the Singapore order of court so readily. And the question then is your counterparty Singaporean? If your counterparty is Singaporean, then your cross-border risk drops away somewhat. That's one less thing to worry about. But if, for instance, your counterparty is perhaps a Malaysian company, an Indonesian company, an Indian company, then the question then is whether or not you need to also think about the ease of enforcement and the ability to enforce judgments which are obtained in the Singapore court. And the reason for that is apart from the fact of whether or not foreign courts will recognize that judgment, there is a possibility that you can enforce in Singapore, but then you need to ask yourself, does your counterparty have any assets in Singapore they can enforce again? So this are, for instance, properties. This may, for instance, be bank accounts, or I think what you may be able to do is take out writs of seizure and sale. So you may pick up machinery, so on and so forth. But then the question is whether or not all those assets, property, so on and so forth, are they already subject to a pre-existing security interest? Has someone already obtained security over those assets such that you actually have nothing to enforce against? And then there's also the consideration of, and this is actually a very practical point. Even if they are not encumbered and you can enforce, how do you liquidate them? I'll give you an example. Let's say, for instance, I don't know how many of this, whether or not we face this, any of you face this sort of situation, but if, for example, the assets of the debtor company include ships, ocean-going vessels, very large pieces of machinery. The question then is, you have to hold on to these vessels, you have to hold on to this machinery and find a buyer. will you be able to find a buyer? And in the meantime, while you're holding on to the vessels, while you're holding on to the machinery or whatever, is there a maintenance cost involved? How much do you have to pay to maintain all these assets that you're holding on to until you find a buyer? There is no ready solution. It's because all the assets all differ, but these are just the factors that you have to think about before you pull the bullet. Okay, and of course, so coming back to this, so once you assess that there is likely to be a potential default, the next step is what do you do? And obviously one of the things that I think Rina has mentioned is that you will want to negotiate with your counterparties. That's relevant in Indonesia and Singapore. It happens all the time. And the question is, how do you best do so while protecting your position? Rina mentioned that what you want to do is you want to reserve your rights, and that applies equally in Singapore. So you will, of course, reserve your rights by sending what we call an open letter. An open letter meaning something that can be disclosed in court if it ever comes to it, saying that I have reserved my rights and I am protecting my rights. Okay. Then the next question is, how then do you go about negotiating with your counterparty in the meantime? Okay. And what we recommend is that when you do so, you negotiate with your counterparty under cover of without prejudice communications, i.e. to say that you expressly mark your letters, your emails, your faxes, your WhatsApps, your SMSs, whatever it may be, you mark it without prejudice. What is this concept without prejudice before I go further down? The starting position is that when you go to court, when you go into litigation, the court will look at all the evidence, will look at all the documents, okay? And assumes that parties are bound by what they say or what they write, okay? What a without prejudice, what a communication that's marked without prejudice does is that it prevents the other party from relying on that document. So it means that, for instance, let's say I'm entitled to sue B now because B owes me money that's payable right now. But I'm prepared to negotiate with B, and I say, hey, okay, B, I'm okay to let you pay me in installments of maybe three in 3 or 4 weeks, and then if I don't mark that communication, that offer without prejudice, B may come around and say, hey, you have agreed to this debt repayment scheme such that you can't actually sue me now for the full sum. And so that is going to be a problem if you actually want to enforce your legal rights in court, your entitlement to receive payment immediately on the spot. But if you mark that communication without prejudice, that covers any admission that may be made. If, for instance, and also if, for instance, you do acknowledge that perhaps the other side may have a counterclaim against you. Okay, this is subject to certain exceptions. One of which is you cannot use a without prejudice label to cloak, i.e. to prevent disclosure, to hide an agreement that's already been agreed. So what do I mean? So for instance, in the course of your without prejudice discussions, parties have reached an agreement on a debt repayment scheme. So it's been agreed that, okay, you'll pay me in installments every 4 weeks, 4 weeks, 4 weeks. That culminates in an agreement. You can't then use a without prejudice label to stop that agreement from coming to light. Parties will be bound by any agreement they reach, even if it's exchanged in the course of without prejudice discussions. Okay, so I now turn to enforcement. So enforcement, to be clear, enforcement can take place in parallel to without prejudice discussions. In fact, we would generally recommend that you give thought to your enforcement options and considerations, even while you're undertaking parallel without prejudice discussions. The considerations are manifold. One is you first, as Rina has, I think, also noted, you identify all the potential defaults and your rights and obligations under the documentation. One, do you have a right to accelerate all payment obligations? For those of you which are finance companies, there will normally be such a clause, an acceleration clause, which entitles you to accelerate all payment obligations, even those which have strictly speaking yet to fall due, but you have to look at the contract. And the next question is relevant to any potential self-help remedy which you may have. Do you actually have a right to stop performance of your existing contractual obligations, or are you obliged to keep delivering, keep performing? And this is actually important, because if what you want to do is you want to cut loss, stop loss, minimize exposure, and one way to go about doing it, a self-help way you go about doing it, is to invoke your own contractual rights to stop performing if you have such a right. Okay, and obviously the third will be, can you terminate the existing contract? And you need to be very clear whether or not you actually have that right, because if you do not have that right and you terminate a contract wrongly, you yourself can be liable to be sued in damages for wrongful termination of contract. And notice provisions is relevant because you will need to give notice to the counterparty. For instance, if you want to accelerate your counterparty's payment obligations, or if you want to terminate the contract, the manner in which you give notice must be done in accordance with the notice provision in the contract. So you need to read that pretty carefully. And then you need to identify whether or not your contract itself is actually governed by Singapore law, and what is the appropriate dispute resolution mechanism. And I'll give you an example. We dealt with a fairly small matter recently. I think the claim was maybe about 50 or 60K. But unfortunately it actually involved a counterparty that was in Singapore, but and that would have been okay. The problem is that the dispute resolution mechanism was actually very complex, and it provided for arbitration, but you first have to go through mediation, and it's a very sophisticated arbitration clause. I think what happened is that people basically took a random arbitration clause, put it in without realizing the implications. And what is the upshot of that? The upshot of that was that we advise our clients, look, even if you were to sue the counterparty in the Singapore court, the counterparty will say, look, court, there is actually a sophisticated arbitration clause. Parties should be bound by it. And what it means is that they can stop you from suing in the Singapore court, force you to go through a costly and complicated arbitration procedure. So you need to be very mindful of that, because that will frame your decision-making matrix and how you engage with your counterparty. And then, of course, once you've identified the correct governing law and dispute resolution mechanism, then you want to find the correct lawyer. If at the end of the day the contract counterparty is, for instance, Indonesian, the contract is governed by Indonesian law, enforcement is likely to take place in Indonesia, then it may make sense for you to just speak directly to an Indonesian lawyer as opposed to a Singapore lawyer, because this way, obviously, you save legal costs, and so far as you are right off the bat, you are speaking with the lawyer that can assist you the best. Okay, and then you look at personal guarantees and security. Do you have recourse to personal guarantees and security to satisfy any outstanding payment obligations? And you consider whether or not you the counterparty has left existing deposits with you, because if they do, you have to consider whether or not you actually have the right to set off, i.e., I mean, loosely speaking, sweep the deposits to minimize your exposure. Okay, and again, you have to examine the contractual set-off clause in some detail to ascertain whether or not that right has actually crystallized, and you have the right to do so. And of course, just before you start litigation or start the actual enforcement proper, you may want to send a demand letter. Some of you may have heard the phrase statutory demand. What is the difference between a demand and statutory demand? A statutory demand, if unsatisfied, results in a presumption of insolvency, and normally it is a shot across the bow that you intend to liquidate, intend to wind up the company. A demand letter doesn't necessarily have that effect, whereas statutory demand has that effect under the insolvency legislation. And so sometimes some of you may often have this idea, let's just shoot a statutory demand right off, and threaten the debtor company, because the debtor company will be afraid. And I think it may have implications, especially if the debtor company is a group of company. But before we actually decide to do that, I think we have to ask whether or not the debt is actually a legitimate one. Is it disputed? And is it disputed on genuine grounds? Because you cannot actually you should not be issuing a statutory demand or winding up application on the basis of a debt that is disputed. This is the only case that I will refer you guys to. This is actually the case of BNP Paribas and Jurong Shipyard. So what happened is that Jurong Shipyard actually owed some monies to BNP Paribas, the bank. And Jurong Shipyard basically said, well, actually, I dispute the amounts that are owed to you. Nevertheless, BNP Paribas issued a statutory demand, which in effect is an implied threat to wind up Jurong Shipyard. And the Court of Appeal, which is the highest court in Singapore, had this comment to say, where in effect, where the debts are not admitted or where there are genuine bona fide cross claims, you should not be issuing a statutory demand because that heralds a winding up application, and this implies insolvency and can damage companies' creditworthiness or financial standing. And especially in debtor companies which have related companies, normally you have cross default clauses. Cross default clauses are, for instance, if company A is the subject of a winding up application, it results in a default on companies B's facilities as well. So you need to be very mindful of such things. So the Court of Appeal has basically said that, look, fine, you have a right to issue a statutory demand, but that is something which should not be issued when there is a dispute, a substantial dispute on the underlying debt. So you need to be very, very careful about this. Okay. Having issued the demand letter or statutory demand, the next step, if you're minded to sue, i.e. go through the court process, is basically whether you want to take out a civil claim or a liquidation. Liquidation being winding up proceedings. And I've set out on the table before you some differences. So if you do a civil claim, there are three thresholds to bear in mind. If your claim is small enough, i.e. less than 20K, you can do it in the small claims tribunal. Small claims tribunal, lawyers can't be present. And what actually happens is you can represent yourself. Okay. Obviously, this has the merit of saving legal costs, but it does mean that you have to know your case well, and you have to be able to convince the judge, convince the small claims tribunal referee that your case should prevail, especially if the other side contests your case. Okay, state courts. This is basically the building at Havelock Road. It has jurisdiction. It can hear cases of less than $250,000. Anything more than 250, you have to go to the High Court. High Court is the one High Street near Parliament House, National Gallery. The difference between a civil claim and liquidation is this, and I'm on the third line item. What is the outcome if the process is successful? If you succeed in your civil claim, you obtain a court judgment. Court judgment belongs to you and only you. You can take it, you can enforce against assets of the debtor company, but of course the enforcement considerations are those which I've shared earlier, whether or not there are unencumbered assets of the debtor company which you can enforce against, or if not, what you may end up having is a paper judgment. And crucially for this, and this is the difference between a civil claim and a liquidation, is you cannot go into the company's books to ascertain the company's assets. You can enforce against assets which you know about. You may be able to take out certain court procedures to have the directors attend court to disclose the company's assets, but that takes on an additional process. Whereas in a liquidation, what you do if you're successful and you get the company to be wound up is that you actually appoint the liquidator. A liquidator takes charge of the affairs of the company. He goes in, and he or her is able to investigate, ascertain whether or not there were any wrongdoings, and if there were wrongdoings, the liquidator has the right to commence proceedings to sue the directors of the company for breach of directors' duties, and any recoveries will then be shared. Of course, the flip side is that in a liquidation scenario, your assets are actually shared with other creditors on a pari passu basis, i.e. ratably. You don't have the ability to say that everything belongs to me. You must share with all other creditors. Okay, and in both cases, there must be some nexus in Singapore. I'm on the second line item. So again, it goes back to where do you want to sue and which are the lawyers that you should speak with. I'm going to touch briefly on the insolvency of a debtor company. I think this is a bit technical. I'm not sure how many of you have been interested in this, but this may be relevant in so far as we're talking about insolvency. There are two ways in which you can show that a debtor company is insolvent. One is it's presumed to be insolvent, in which case you normally what people do is that they issue a statutory demand, and which is not satisfied. Presently, your statutory demand must be for a sum of at least $15,000 Sing dollars, and if it's not satisfied there, under the IRDA, under the Insolvency, Restructuring and Dissolution Act, the debtor company is presumed to be insolvent. Okay, if not, the alternative is you seek to actually prove that the debtor company is insolvent. The Singapore courts look at two tests: one, whether or not the debtor company is actually cash flow insolvent. Cash flow insolvent meaning it's not able to pay its debts as and when they fall due, and two, or if not, whether or not it's balance sheet insolvent. I look at the asset liability position on its financial statements. This can include management accounts. This can include audited financial statements to ascertain whether or not the company is actually insolvent. And if you are actually insolvent, then you have the ability to wind up the company. Okay, I'll now move on to the second last bullet point of my original overview. That is what is the overview of the restructuring and solvency regime in Singapore. I've touched on liquidation, so the remaining two is judicial management and schemes of arrangement. These are what we call corporate rescue, corporate rehabilitation regimes, where they exist if the court believes that actually the company has a chance of being rescued, has a chance of being rehabilitated. So returning back to liquidation, what are the effects of liquidation? The liquidator, as I briefly mentioned, has the power to investigate the affairs of the company. And if, for instance, and this is quite handy, for instance, if there is fraud involved, the liquidator can take steps to sue the directors of the company to replenish the assets of the company for the benefit of all creditors. The issues which arises, the biggest issue which arises is whether or not your debt is disputed. If your debt is disputed, then you cannot issue a statutory demand. It is an abuse of process of the court. This is because the winding up application, when it's issued, it must be advertised, and that has the ability to cause a lot of damage to debtor companies and the related group of companies. And then, of course, there are costs involved. The cost is because, one, when you take out the winding up application, you must pay a deposit to the offshore receiver's office. That can act as a deterrent, especially if your claim isn't that large. The deposit, as I understand, is presently $10,400. So that's something that must be paid up front. And on top of that, the courts may encourage you to appoint a private liquidator to administer the affairs of the company, and those fees may add up quite a little bit. So you need to be quite mindful of that. The effects of the liquidation, the winding up order, is that the company ceases to survive. It does not stop secured creditors from going around to enforcing their security, to enforce their security. So there is a possibility that if you're unsecured, as Rina has noted as well, you may end up not getting very much at all. Restructuring regimes in Singapore, I don't want to go into this in detail. I'll just leave this slide on the screen. But this is relevant only insofar as the company takes the view that it has the ability to save itself, in which event then it has two options. One is to try to go for a scheme of arrangement, or two is to put itself in judicial management. Broadly speaking, both give you a moratorium. The moratorium, what is a moratorium? Moratorium basically it restrains all creditors from doing a variety of things. One, it stops creditors from suing the company or continuing to sue the company. It stops creditors from attempting to wind up the company or to continue winding up proceedings. It stops creditors from enforcing their security or taking any steps to enforce their security. The whole idea is that in the course of the scheme of arrangement and judicial management, the breathing space that's provided by the moratorium is intended to allow the company to restructure its debts, to come out with a rescue plan, which may result in creditors taking a haircut. But the idea being that at the end of the day, notwithstanding the haircut, the company survives. And there is a greater good to having the company survive, because if the company goes into liquidation, people will lose their jobs. If, for instance, the company is simply facing a temporary cash flow crunch, having a temporary moratorium, breathing space, may allow a company which is fundamentally strong to tide through. So this is actually one of the schemes of arrangement and judicial management are actually some of the very common corporate rescue regimes that are deployed if the management thinks that a company is something that can be saved. The difference is that a judicial management is actually has external judicial managers. These are normally external accountants come into the company. They manage the company's business and affairs. Whereas in a scheme of arrangement, it's the existing management that retains control of the company, and this has implications, I think, because if for instance in a scheme of arrangement sort of scenario, some creditors may not be comfortable having the existing management retain control of the company. They think that the existing management is perhaps guilty of some wrongdoing, or there's simply a loss of trust and confidence, in which event then the preference will then be for the company to put in judicial management, because the judicial managers, in effect, they become the directors of the company. They manage the companies, they manage the company pending the outcome of a restructuring. The COVID-19 Temporary Measures Act, I'm on the last part of my presentation. This was actually, I think it's been pretty high profile. It came into force earlier this year. We were one of the first few jurisdictions around the world which put in place some sort of COVID-related measures to give debtor companies some degree of relief. The requirements, the test is basically there. Counterparties and their guarantors may enjoy a COVID moratorium where there is a contractual obligation to be performed on or after 1st February, and that inability to perform is caused by a COVID event. And it's important that we understand this, in that the obligations will be suspended, but they are not absolved or extinguished during the moratorium. I to say that if, for instance, even if you're entitled to COVID-19 relief, your interest payments still continue to run, and this includes your default interest payments as well. So I think that there are debtors, I think, who may not appreciate that, and they may try to invoke the COVID relief without actually realizing that if you actually do have the ability to pay off some of your loan repayments, you should probably do so, because if not, interest and default interest continues to run. So it was slated to expire just yesterday, but as most of you may have read the news, it's actually been extended. So for loans to SMEs, it's been extended for a month. And there are different tiers. So you can see that for events and tourism related contracts, that's been extended to 31st December. Construction related contracts and performance bonds actually go into next year, and this because for a good part of this year, I think the construction industry is heavily reliant on migrant workers, and as many of you will know, they bore the brunt of the COVID pandemic. And so so what happens after the COVID moratorium expires? Parties are obliged to continue their existing contractual obligations. Contract continues as per normal, and as I've noted, be very mindful that if your interest and your default interest doesn't stop running, it actually continues to pile up. So it may be that at the end of it, once the COVID measures are lifted, you may find yourself actually facing a greater debt obligation than you otherwise would have faced. So I think that is what I have right now for me. I think Tiffany, I think we're happy to take questions.
Okay, and thank you very much, Justin. Thanks for the wonderful presentation. So without further ado, let us welcome back our two speakers for the Q&A session. Now, if you have any questions for our speakers, feel free to submit them by clicking on the Q&A button at the bottom of the screen and type in your questions. Do note that as we have limited time for the Q&A sessions, we may not be able to answer all the questions during this event. Now, we seek your kind understanding that should your questions not be able to answer during the session, please contact Indonlegal, Works, and JWS Asia Law Corporation directly with their contact details featured on the screen, or email SCCCI, and we will forward your inquiries to them too. out. And we would like to answer the first question, which is by Joey. Okay, sorry, Joy. So Joy has these questions of, she just like to check that if can creditors visit the debtors do a site visit at the debtors? Is there any legal issues to visit the defaulting companies? Can they visit the registered, the shareholders' residential address to collect the debts? So I think what's more for Joy is more like, if in the case that they really has exhaust all ways and means to try to contact the companies itself and they really can't get hold of them. From the legal perspective, is it all right for the creditors to visit them, physically at the site to do the collection of the debt? So maybe I can have Justin and Rina to help to answer Joy question on it.
Yeah, so maybe I answer it from the Indonesian law point of view. For visiting the company itself, actually it is okay, provided that the company allows you to visit. And usually you should give them a notification first that you'd like to visit their company. And then in terms of visiting shareholders, let's say the shareholders are individuals, we got to be a bit more mindful about that because some individual shareholders might take an offense by visiting them individually, because as a matter of law, actually shareholders are not responsible to the obligations of the company itself. And we just don't want to avoid there could be issues that, let's say the shareholders are not happy, they could call the police or could involve in like data privacy breach, like how come you know my residential address and you come and visit me. But if as a matter of courtesy we inform them first and they are okay for us to visit, there is no harm. As I pointed out earlier, actually to have a friendly and open communication with the counterparty is the key. That's all from me.
Yeah, I think from my perspective, it's largely similar. There's nothing to stop you from visiting the debtor company's address. Of course, there are considerations that need to bear in mind. If, for instance, it's made clear that you are no longer welcome on the premises, then you should leave, because otherwise the debtor company may be able to say that, well, you have trespassed onto my premises or you're harassing me. And the other practical tip, of course, is try to keep some contemporaneous evidence that of your conduct at the premises. So for instance, I would suggest maybe take a video such that if the data company says that, well, you came inside, you're harassing me, you were shouting at my stuff, so on and so forth, it's all captured on evidence. As to whether or not you can go to the register, the shareholders address to collect the debt, as Rina has correctly pointed out, a company is actually a separate legal entity from its shareholders. So the line here is a little thin. You can go and say that, look, you are in effect the owner of the company. You are 100% shareholder. Would you like to make payment of the company's debt? And leave it as that. Because that aside, there's probably not that much more you can do, especially if the individual in question says that you're harassing me and you're trespassing my premises.
Okay, thanks, Justin. Thanks, Rina. I think moving forward, Joy also add on in her question down there, despite they sending like 3 reminders, emails, reminder letters, and but the company still do not respond, and even email and contact numbers are not valid anymore. So I think not just Joy, I think many of the participants or on the day-to-day business company, it's easy to say, hey, we try to talk it out amicably, friendly, try to see how we can help them. But if in a worst case scenario, to what extent, does someone need to really take into legal actions really? Since, I call you, you also don't answer. I email you, you also don't answer. So maybe Justin and Rina, you all can provide the participants, an idea about what is the worst case scenario if no matter how they try to reach out to the company, but the company is just, ignoring all the calls and emails from them.
I think from my perspective, then you have to assess whether or not you want to go down the legal route. There is no easy answer. It's easy. I mean, for me, I would say that, well, I mean, go for it, because it gives you closure. But of course, you have to consider whether or not your ability to enforce and prospects of enforcement are there. But I think one possible option, if and this This applies if there is no response, but you know that the company is still its premises, or you know that it is checking its more like premises. One option is to issue a statutory demand if your debt is more than 15K, and leave it at a registered office. If I think a well-advised company upon receiving a statutory demand will know that this threatens its very existence. So normally that tends to get people's attention. But again, I want to stress that you should only do so when you know that there is no dispute to your debt.
Yeah, so my answer is similar to Justin, because if the companies do not respond and they still have an office premise, then that's easier. Perhaps you can assess that whether with the amount of the debts you want to litigate at the Indonesian courts, or you just take the cut. But if, let's say, the companies already shut down the offices, or they already closed down the office, and also no email and contact numbers can be contactable, that would be actually tougher, because even if you submit a claim, to which address you should go, and maybe they have liquidated their assets or in the process of liquidation. So that's something that you need to consider and assess the consequences as well.
Okay, can sure. Thanks, Rina. Thanks, Justin, for answering. I hope that helps to answer quite a number of participants' underlying questions. Now we do have David also. David question is here. There's no contract agreement. How can they claim their non-payment? I think sometimes, being businesses, sometimes we always say, hey, we trust, we go by trust. And, maybe in terms, it's just an email or just a verbal, hey, today I need a certain number of products. So maybe what are the other things can companies go about if there's no proper contract agreements to go about, and payment starts to default away? So maybe can I have you guys advice?
Yeah, so in practice, I do encounter that some parties do not have a contract, because could be just a one-off trade of the products. And actually, evidence can be also from emails, correspondence, or invoices, or the purchase orders. So it came to the point that I mentioned earlier, that if you have a complete correspondence filing, then that's a very good practice, because in the event of default or dispute, then you can protect your position by having complete evidence showing that you are entitled to a certain amount against the counterparty.
Yeah, so I think in a similar manner as what Rina has described, if there is no contract, that is not the end, because as a matter of law, the agreement that's reached can be found can be reached through correspondence. When I say correspondence, I use it in a fairly broad fashion. So it can be an agreement that's reached over emails. It can be an agreement that's even reached over SMSs or WhatsApps. It can be an oral agreement even, obviously, but I mean, whether or not you can prove the existence of an oral agreement is a separate matter. But the fact that you don't have a very nice looking contract is not the end of the world, because there must have been a reason why goods were supplied, services were supplied, and monies are owed. Normally there must have been some sort of understanding, and the key then is in identifying what was that understanding, what was the agreement that was reached. I think if I mean, in this day and age, most of your understanding, most of your correspondence would have happened over electronic messages, electronic emails, so on and so forth. This is not a time when 40, 50 years ago, when stuff happens in letters, you lose letters, so on and so forth, or people meet up and then it just happens without any understanding, it's just verbal. These days, there is normally some paper trail involved. It's just a question of finding that paper trail.
Okay, can share. Thanks, Rina. Thanks, Justin. I hope that answers David's question. Now, I understand that, sometimes, like what Justin have said previously, probably you want to check on a company, whether are they having any litigations or, legal sue going on to see some of the red flags. Now, I have a question by Yong Han. He says that, where can they check whether the company is under any litigation? So is there any, websites or anything that probably companies can check to make sure that, hey, this company is not having some red flags going on?
In Singapore, normally that can you can do it via the court website, court system, and that happens. It's actually the you probably have to engage a lawyer. If not, you have to go to the Legal Service Bureau to do a search. But all court proceedings will be reflected on that website.
Okay, Kensha, I hope that helps to answer Johan's questions on it down there. Okay, we don't really have much time, so I'll just quickly pick off the one or two last question. For the rest of the participants, rest ensure that even if we did not answer your questions during the Q&A live sessions, we'll be actually sending your questions to the speakers themselves, and they will email you directly addressing your questions that you have posted up on the Q&A sessions. Now, I have another questions by the name of AN. Understand that, we've been always focusing on like B2B defaults. Now, his or her question is that, what about retail related kind of payments? So what he or she has faced is that a patient using Medisave has insufficient fund to pay for the treatment. Then, when they contact the patients, to pay by cash, the patient sort of like disappear or refuse to pay. So what can, the company do for, such B2C related kind of customers in terms of default payment and not just the B2B?
I think that it comes down to whether or not the enforcement options are available. But practically speaking, in such a scenario, it depends on how large the debt is and whether or not how much you want to escalate matters. The reality is that the most cost-efficient method of doing it may simply be that in terms of self-help remedies. I say that if for instance, the next time the patient comes, then you just have to ask for payment upfront or so on and so forth, or if not, of course, the option may then be to actually visit the patient's house, not so much in a threatening manner, but perhaps just understand what are the issues which the patient is facing and whether or not payment can be made, some sort of compromise can be reached. I think at the end of the day, if it hits that point where you are at that point, then taking a 50% haircut may even be better, or taking an installment payment plan. The answer isn't necessarily found in the law.
Okay, Kensha. Thanks, Justin. I hope that answers our AN questions. Now, Justin, I understand that previously you have given an advice on where participants can find the litigations of a company, everything. So there are participants who's asking, can you probably key in the chat group, to inform them where can they find such information like the website or the web page that they can go to. So maybe we have Justin to fill this question up in the chat group for the rest of our participants. Now, I understand there's still quite a number of questions coming in, but I do see a common similarity of questions that is posting up by various participants, and it's always the same thing. Now, for the final questions, I think for Justin and Rina is that many of the participants here said that they tried contacting the other party with emails, WeChat, but none reply when they try to contact their debtors for it. And even some of them even have Indonesia's overseas companies that own them money. And now, with COVID, you can't just fly to Indonesia physically to visit the company, even despite them emailing them, contacting them through emails, websites, and everything they have done. Okay. So overall, maybe I will have Justin to address in the Singapore side, what can they do step by step, if this debtors has just went, missing in action and can't be contacted anymore. And as for Rina, maybe you can also advise the participants, if your debtors is based in overseas, for example, now like in Indonesia, what can they do, without being physically flying to Indonesia and knocking on their doors? So maybe can I have Rina to start off first for the overseas portion for it?
Yeah. So let's say the counterparty is in Indonesia and then you try to contact them, they are not contactable. I think you can consider whether you want to hire an Indonesian litigator and then request the Indonesian litigator to send a somasi or demand letter to the Indonesian company so that they know that you are serious, that if the payment is not being made, you will take a legal actions against them. So that's usually will be the approach. Then you can assess whether that will be the approach you want to go down the road as well. Because if you really want to actually sue them at the court, that there will be extra costs incurred as well.
Okay.
In a fairly similar way, I think the starting position is which is why one of the things that I set out right at the start is enforcement. It's a very important consideration that people don't realize. So if you start off from the position that the debtor company is known to have assets in Singapore, has a Singapore presence. For instance, it has offices, it has office premises, that it has some bank accounts with available cash, so on and so forth, then I would normally, in the usual course of things, recommend sending a statutory demand. If the debt is not disputed, leave the statutory demand at the registered office, and that triggers a process. My experience is that normally a debtor company which is good for the money will respond, because that will have gotten their attention. You may have to spend a bit of cash to issue the statutory demand, because it needs to be in a certain form, and we would normally recommend that you send it by a lawyer. But that will normally get the debtor company's attention. And then after that, it then very much shifts onto the debtor company to decide what they want to do. But that normally will focus the debtor company's attention and start the conversation. If at the end of the period, the statutory demand is not satisfied, then you have to consider whether or not you actually want to go further and to engage in civil litigation, to start suit in small claims tribunal, or whether or not you want to actually start an action in Singapore courts. Of course, if you do it in the Singapore courts, it's going to be costly. We would normally recommend that you get lawyers to do it. You do it in the small claims tribunal. You can do it yourself, and the order of court that you get, you can use it. It's almost as good as any order of court that you obtain in the Singapore court, and you can then take it to go and enforce. But I think that just to recap, I think if you ask what is the first step is identify whether or not there are any assets that are readily enforceable against in Singapore. And then 2, issue a stat demand if there is no dispute of the underlying debt.
Okay, sure. Thanks, Justin. Thanks, Rina. Thanks for the wonderful information. I hope all the participants, at least have an idea, if they are facing some debt issue at the current moment, what are the things that, they can go about. And of course, try to communicate to the debtors, try to solve it amicably, in a very nice and friendly way. But of course, if in the worst case scenario, you have to go to the legal issues, feel free to contact Justin or Rina. We will be actually sending all the participants an email with the speaker's contact details, so that if you have any sticky situation, just feel free to drop them an email so that they can follow up on it. So now we have actually come to the end of the session. So once again, a big thank you to Rina and Justin for their time and valuable sharing today. We hope that you have benefited a lot from the webinar, as we look forward to seeing you again in our future events. So for everyone, please stay safe and healthy, and thank you and goodbye.